Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of Bharati Vidyapith, New Law College, Pune. And today's topic is contract. So, the Section 2, Clause H of the Indian Contract Act 1872 defines the term contract as an agreement which is enforceable by law. So we can say that agreement is an contract is an agreement between two or more parties to do or abstain from doing anything. According to Anson, the law of contract is that branch of law which determines the circumstances in which a promise shall be legally binding on the person making it. So, if we examine the definition of contract, then we can see the two important things for the formation of a contract. First thing is an agreement, and the second thing is the enforceability of that agreement. Section 2 clause E of the Act defines the term agreement as every promise and every set of promises forming the consideration for each other is an agreement. After examining the definition of agreement, we can see two important terms that are essential for formation of an agreement. First is promise and second one is consideration. Classification of agreements. Valid agreements. These agreements are enforceable by law. Voidable agreements. It is an agreement which is enforceable by law at the option of one of the parties. Void agreements. These agreement is not enforceable by law at all. Illegal agreements. These agreements are not enforceable by law because they are against the law. Unenforceable agreements. An unenforceable agreement is one which cannot be enforced in the court of law on account of some technical defects like want of a written form or stamp. Promise. According to Section 2, Clause B of the Act, when the offer is accepted, then it becomes a promise. When a person to whom the offer is made signifies his assent, then we can say that the offer is accepted. There are mainly four kinds of promises: express promise, implied promise, reciprocal promise, and alternative promise. Consideration. Section 2D of the Act defines the term consideration as follows. When at the desire of the promiser, the promisee or any other person has done or abstain from doing something, or promises to do or abstains from doing something, then such act, abstinence and or promise is called a consideration of the promise. In short, the term consideration means something in return, that is quid pro quo. A valuable consideration in the sense of the law may consist either in some right, interest, or benefit accruing to the party, or some forbearance, deterrent, loss, or responsibility given, suffered, or undertaken by other. Meaning of the term enforceability. In Merriam-Webster dictionary, the term enforceability is defined as to make a law, rule, etc. effective or active. In simple words, enforceability is an action which can be made effective by the court of law. For example, an agreement between persons in which either of the parties can legally compel the performance of the other is called an enforceable agreement. So, contract plays a very important role in day-to-day life of a person. Most of the time, people enter into contract without even realizing it. For the formation of a contract, there are many essentials that have to be followed. After the formation of a contract, the next stage is reached, namely the fulfillment of the object the parties had in their mind. Once the object is fulfilled, the liability of other party comes to an end. Thank you all. That's all for the topic today. Please subscribe the channel and like and comment on the video. Thank you so much.